Hello and welcome. I'm Jamie Johnson, an estate planning attorney here in Haymarket, Virginia. I've spent many years helping families prepare for the future, and today I want to talk to you about two documents I consider absolutely essential to any estate plan: the power of attorney and the Advanced Medical Directive. Now, when most people think about estate planning, they think about wills and trust, what happens to their assets after they pass away. But here's something I tell every client who walks through my door. A truly complete estate plan also addresses what happens if you become incapacitated during your lifetime. That's where these two documents come in, and honestly, it can be just as important as your will. Let's start with the power of attorney. In simple terms, a power of attorney is a legal document that allows you to designate someone you trust, called your agent or attorney in fact, to handle your financial and legal affairs on your behalf. Think about all the financial matters you manage on a regular basis: paying bills, managing bank accounts, handling investments, dealing with insurance, filing taxes, or even selling property. Now imagine you're in a serious accident or experience a sudden illness that leaves you unable to manage these things yourself. Without a power of attorney in place, your family will have to go to court to obtain a guardianship or conservatorship, a process that can be time-consuming, expensive, and emotionally draining. With a properly drafted power of attorney, you're choosing your own trusted person to step in and manage your affairs seamlessly. You remain in control of that decision rather than leaving it up to the courts. Now, not all powers of attorney are created equal, and this is where having professional guidance really matters. The general power of attorney gives your agent broad authority to handle most financial matters. This is typically between spouses or between elderly parents and adult children who are taking a more active role in handling their parents' affairs. There are also limited or special power of attorneys. These POAs restrict their authority to specific tasks or a specific time period, perhaps to sell a piece of real estate while you're traveling abroad. This is typically done for sale of real estate by families moving out of town or other specific professional matters. But the type I most often recommend is what we call a durable power of attorney. The word durable is key here. It means the document remains effective even if you become mentally incapacitated. Without that durability language, your power of attorney could become invalid at precisely the moment you need it most. Here in Virginia, we also have the option of a springing power of attorney, which only takes effect upon a specific triggering event. Typically, your incapacity is certified by a physician. This can provide peace of mind if you're not comfortable with someone having immediate access to your affairs. I recommend a combination of general, durable, and springing power of attorneys. In my years of experience, I have found that all power of attorneys should be durable, but that the primary agent should be a general power of attorney. If the primary agent is the spouse of the client, with a springing power of attorney for an adult child of the client, as a secondary or backup agent. So the power of attorney handles your financial affairs. But what about your healthcare decisions? That's where the Advanced Medical Directive comes in. And I'd argue this document is just as critical, if not more so, because it involves the most personal decisions we can face. An Advanced Medical Directive, sometimes called a living will or healthcare power of attorney, is a legal document that does two important things. First, it allows you to appoint someone you know, love, and trust as your healthcare agent. This person will make medical decisions on your behalf only if you're unable to communicate your wishes yourself. This might be a spouse, an adult child, a close friend, someone who knows you well and understands your values and wishes. Second, it allows you to express your wishes regarding end-of-life care. Do you want life-prolonging treatments if there's no reasonable hope of recovery? How do you feel about artificial nutrition and hydration? What are your wishes regarding pain management and comfort care? These are deeply personal questions, and an Advanced Medical Directive ensures your voice is heard even when you can't speak for yourself. I've seen families torn apart by disagreements over a loved one's medical care when there was no clear guidance in place. An Advanced Medical Directive isn't just about you. It's a tremendous gift to your family. It relieves them of the burden of guessing what you would have wanted during an already incredibly difficult time. It also ensures that your healthcare providers know exactly who has the authority to make decisions and what your preferences are. This can prevent confusion and delays in critical moments. Let me share a few practical tips as you think about these documents. First, choose your agents carefully. These should be people you trust completely, people who will honor your wishes even if they personally disagree. It's also wise to name at least one alternate agent in case your first choice is unable or unwilling to serve. You can appoint co-agents to act together on your behalf. It is my experience that this works fine with power of attorneys. However, it can become a nightmare when dealing with advanced medical directives. Your power of attorneys can share responsibilities, divide and conquer the legal and financial issues that your incapacitation can create. However, when dealing with medical decisions, it is best to appoint a singular agent to be the decision maker. Agents make decisions. Committees rarely do. The more agents you have making medical decisions, the less likely that a consensus will be reached and a decision made. Second, communicate with your agents. Don't just sign these documents and put them in a drawer. Have honest conversations with the people you've named. Make sure they understand your values, your priorities, and your specific wishes. Third, keep these documents accessible. Your healthcare agent can't act on your behalf if no one can find your advanced medical directive. I recommend keeping copies with your agent, your primary care physician, in a secure but accessible location at home. Finally, review these documents periodically. Life changes, relationships evolve, circumstances shift. I generally recommend reviewing your estate planning documents every 3 to 5 years, or after any major life event, like a marriage, divorce, birth of a child, or significant health change. I know these aren't the most comfortable topics to think about. None of us likes to imagine a time when we might not be able to make our own decisions. But taking the time to create a power of attorney and an advanced medical directive is one of the most loving and responsible things you can do for yourself and your family. These documents give you control. They provide peace of mind, and they protect the people you love from difficult decisions and unnecessary legal hurdles during already challenging times. If you don't yet have these documents in place, or if it's been a while since you've reviewed them, I'd encourage you to make that a priority. And of course, our office is here to help guide you through the process and answer any questions you might have. Thank you for spending this time with me today. Take care of yourselves and take care of your families.